All right, and we are live. So, for everybody that will be joining us today, please take a look at the disclaimer before we start. So, we're going to give y'all about 20 seconds or so to really familiarize yourself with the information that is on the screen. And then we're going to move to Mr. Jerrod Williams, who's going to break down the Safety Act for us. So, I'll give you a few seconds now to just read it over. Thank you so much for your time. All right. So I gave you all just a little bit more time because in recent news, things have shown that some people just don't read exactly the way the information that's presented, and sometimes they just read the headline. So I gave you a few more minutes to look that over. That being said, we're here all because some things need to be delved into a bit further, especially as it relates to this Safety Act that is going to take place January 1st of next year. And a lot of people are up in arms about it. Some people are calling it the purge, and some people have other choice words for it. And there's a lot of uproar as it relates to what exactly is going to happen. So, what we want to do is we want to dispel any misinformation that you may have been given, and also to give you the correct information so that you could best prepare yourself with all the knowledge that you need in order to move forward the best you can when January 1st hits. And so with that, I'm going to go ahead and bring in Mr. Jerrod Williams to talk a little bit about himself, why he's the perfect person to help us understand this act, and then we're going to move forward into some questions as it relates to the act. So, Mr. Jerrod, how you doing today, sir?
I'm very good, Deondre. How are you?
I'm all right, man. I can't complain.
So, thank you for that introduction, and thank you for everyone who's joined us here today. It's important, as Deondre said, to have correct information and not believe some of the rhetoric and bluster that's surrounding this act. And I want to thank you all for coming here today to try to get some information. So, I'd like to begin by saying, what are we talking about? What is the Safety Act? And that's important because while there has been a lot of focus on the changes that it has made to the bail system in Illinois, which are both important and historic, it does much more than that. The Safety Act itself is a sweeping criminal justice reform bill that actually has quite a lot of very beneficial provisions in it. And I'd like to highlight a few of them for you. And before I do, I'd like to share not just the information that we have, but the sources of that information with all of you, because as Deondre suggested earlier, it's important to read these things for yourselves. So you're not required to take my word for it. I will give you the website, a convenient website where you can find a lot of this information. And if you like, you can go through and read it for yourself. And I do suggest that you do, because I'm just going to give you some highlights, but there's a lot more to talk about. Again, by way of introduction for myself, my name is Jerrod Williams. I'm an attorney. I've been an attorney in Illinois for almost 20 years. I'm a member of the Illinois State Bar Association Committee on Racial Equality and Justice, which is focused very heavily on the implementation of the Safety Act and trying to educate the public. And however, as the earlier disclaimer stated, what I'm about to tell you should not be construed as legal advice, and it does not create an attorney-client relationship between myself and anyone viewing this video. These are just my understandings of what this law is. And again, whenever possible, I'm going to give you the source of that information so that you can go back and read it for yourself. If you have specific questions, if you or a loved one are involved in the criminal justice system, and you are involved and you have questions about what this act means for you individually, I strongly encourage you to consult with an attorney. You should not use anything that you hear today for as legal advice. You should take it as information to help educate the public, which is why we're here. And thank you, Deondre, for bringing this information to the public and for allowing me to do this.
Yes, sir.
So I'm going to start with some information that comes from the Illinois Criminal Justice Information Authority. And they have a website at icja.illinois.gov. So this is a government website. It's the Illinois Criminal Justice Information Authority. So the website is icja.illinois.gov, or just Google Illinois Criminal Justice Authority, and you can find their website. And everything, this next piece I'm about to tell you can all be found just right there on the website. So what is the Safety Act? That's what Deondre asked me to talk about. Again, it's a very broad piece of legislation, and it does a lot. It has changes to the criminal justice system in some key areas. Those areas include the use of force, complaints about police misconduct, certifying police. Police do have to be certified. It's a licensed position. You have to have a license to be a police officer, and certain other policing provisions. And of course, the big piece that everyone's talking about now are the changes that it has made to pretrial practices in Illinois. And when we say pretrial, we mean everything that happens between the arrest and the actual going to trial. But let me talk about some of those other provisions just very briefly. With regard to use of force, the Safety Act offers a new standard for when police can use force. It requires police to provide assistance once they have used force, and it requires officers to intervene if other officers have used unauthorized or excessive force. Now, obviously, that last one invokes what we saw with the death of George Floyd, where he was slowly being killed before our eyes, and yet other police officers who weren't actively doing it simply stood by and watched. Well, the Safety Act addresses circumstances just like that. It also creates different avenues for complaining about police officers. And what I find most significant is that it allows the Attorney General to investigate what are called patterns and practices of police misconduct. Now, patterns and practices is something that you may have heard in the past. It's the standard by which the Department of Justice uses when they come in and conduct their reviews of police departments. Now, as I'm sure most of you know, the Department of Justice really recently entered into a consent decree with the Chicago Police Department because it found a pattern and practice of misconduct in the Chicago Police Department. And that's what results in these consent decrees that are designed to achieve reform. This now allows that process to happen at the state level. So the Attorney General can institute one of these investigations. So this no longer leaves us beholden to the federal system to step in, examine the regular everyday practice of a police department and determine if changes need to be made. And another important thing that the Safety Act does is it allows for mental health professionals to accompany police on certain calls where a person, police intervention may be needed to protect the public, but it's because the person involved in that activity isn't necessarily engaged in criminal activity, but they have some sort of mental health issue that needs to be addressed. And this way we can get them the specific help that they need, rather than using a law enforcement solution. We can use a mental health solution. And the big piece, of course, is what happens pre-trial, and that's primarily what we're going to be talking about today. And when we talk about what happens pre-trial, what we're talking about is bail. As we all know, when a person gets arrested, they go to jail, and in order to get out of jail before their trial, heretofore, up to now, they have had to post bail. Well, The Safety Act does eliminate cash bail in Illinois. And I believe we are the first state to completely eliminate cash bail. And there's been a lot of controversy surrounding it. As Deondre said, people have called it the purge. I assure you it is not, but we're going to get into more detail about that.
Thank you. Great overview. So is there anything else you wanted to add in addition to what the act creates, or did you want to go ahead and move into some questions?
Well, I'll just add this. It does create actually quite a bit more. It does, as this is a sweeping, massive criminal justice reform bill. And as a side note, it's actually been attacked on that very basis, saying that it actually does too much. And that relates to a law that we have in Illinois called the single subject rule. It's my opinion that the single subject of the Safety Act is criminal justice, and therefore it does not run afoul of that rule. But nonetheless, it does so much that people are actually using that as a basis of attack. But it does a lot. Be sure to visit that website, Illinois Criminal Justice Authority, and you can read a lot more about it.
Gotcha. And do I have it correct up on the screen? icjia.illinois.gov.
Let me take a look. I'm sorry, I have it on. One moment. Let me get to it. I see
the website you mentioned it a bit earlier.
Yes,
you want to make sure
that is it. I see. Yes, that is correct. That's the site. Visit that site, and it's on the opening page, and you can read. It's a nice bullet points. You can read all about the Safety Act.
All right. So for those that are watching in, that will be watching in as we put this recording up, please go to icjia.illinois.gov to find out more about the Safety Act for yourself. If in fact this broadcast does not work for you, read for yourself. And that being said, so with this overview, did we want to go ahead and move into the question portion, or was there anything else you want to add?
No, let's move on.
All right. So I think everybody wants to know what happens on January 1st.
Exactly. Because as you said, there's been a lot of what I believe to be scare tactics, calling it the purge, where people have been given the impression that on January 1st, police in every county across the state are going to be required to go to the jail and basically throw the doors open. And let everybody walk out. I assure you that is not the case, and that will not happen. But so January 1st is the date that the Safety Act goes into effect. And as I said, the most controversial aspects of it has surrounded what it does with the bail system, which again, you get arrested, you're taken to jail. If you want to get out of jail before your trial, you had to post bail. So that's the context that we're talking about. But I think it's important. Let's start with some basic background information about that arrest and bail process, because it's important to understand it based on why we do it and what its purpose actually is. And the Safety Act goes a long way to better achieving that true purpose. So allow me to explain. When you call the police and someone is committing a crime, it doesn't matter if they're actually in the act of committing the crime. It doesn't matter if you catch them red-handed. Police can certainly come arrest that person, and they will continue to be able to arrest that person. That's something else we're going to talk about a little later. But yes, police can and will continue to be able to arrest that person. But it's important to remember that person is innocent of that crime. They have not been proven guilty beyond a reasonable doubt. So it's not that we consider them innocent or we treat them like they're innocent. They are actually innocent people. They have not been proven guilty of anything. Police may have had probable cause to arrest them, but they are innocent. So when we're talking about keeping people in jail before their trial, let's all remember that we're talking about keeping innocent people in jail before they go to trial. So these people are innocent. We're talking about keeping innocent people in jail. And we can do that. But the reason we do that is to make sure that, number one, they don't hurt anybody else. And number two, to make sure that they actually show up for their trial. Now, up to now, we've done that by making them post bail. And they didn't actually have to post the full amount of the bail. They only had to post a 10% bond on the bail. And the theory was that innocent people, particularly, wouldn't want to lose that money. It can range into some very significant amounts. And the theory was that, well, if we make them post a bond, they will come back to their court date because they want their money back. So I challenge you, Deondre, and our audience, to just think about this for a moment. What if you're someone who doesn't care about the money? What if you, A, have the money, and B, don't care about losing it? Have we achieved our purpose of making people come back to court in that situation? I'm not going to offer an answer. I'll leave that to yourself.
Mm-hmm.
But the problem is that most people who get arrested for crimes don't have the money. That's the problem, and that was the unfairness in the system that the Safety Act was looking to correct. So not only do most people arrested don't have the money, particularly most Black and brown people who get arrested don't have the money to post their bond. Because even on a $50,000 bond, you're talking about $500, and $500 ready cash can be difficult to come up with for anybody. It wouldn't be a walk in the park for me, certainly. So what was happening was we were locking people up, again, not because they're guilty, because they're not guilty at that point. They haven't been proved guilty by the state beyond reasonable doubt after a trial. So they're not guilty. So we're not locking them up because they're guilty. We're not necessarily locking them up because they're dangerous. And we're not locking them up because we think they're going to run away. Because there's some sort of indication in their past that think, this person has relatives in France, and if we let them out, first thing they're going to do is jump on a plane and go to France, and we can't have that. That's not the reason. Because those questions weren't asked. The sole reason people were being locked up was because they were poor. That was it. So you're talking about primarily Black and brown people. You're talking about poor people, and these are people who have to stay in jail for that reason alone. And that's wrong. That is both morally wrong and legally wrong. And the Safety Act tries to correct that injustice. Now, after January 1, what happens is that people can only be locked up because locking them up is the only way to protect people or protect the community and to make sure that they come back. That is that was the whole purpose in the first place. But now the Safety Act ensures that those are the only reasons that people can be locked up. And not only that, the state must prove that locking them up is the only way to make sure that they don't hurt themselves or other people and that they come back, rather than just us guessing for the sake of argument that they're going to hurt somebody or not come back, which was sort of effectively how the old system worked. Now the state has to actually prove it. So that's the background that we're talking about when we're talking about this whole bail system and what it is that we're changing. And that's important for people to remember.
Absolutely. Can I interject with a question of my own, which I'm sure most people would also have, because the panic has come from the more serious offenses that have been listed as cause for concern. Things like I believe it was like I don't even want to put what I believe to be true. So I'm just going to ask about the more serious offenses, felonious offenses that individuals are having trouble with understanding, and why they believe that people that commit these more serious offenses will be let out. So, do you have a response to that as it relates to the Safety Act allowing or having language that suggests people that commit more serious offenses will be afforded the opportunity to have this no cash bail?
Right. So what has been reported is that the Safety Act creates this certain category of crime where you cannot be detained before trial, and they've listed some very serious offenses, offenses like certain domestic battery offenses, and the one that I hear a lot is second degree murder. People are claiming that you could be accused of second degree murder, but police cannot, it will not be allowed to, under any circumstances, to keep you in jail, even though you're charged with some of these very serious offenses. That is not true. That is incorrect information, and I want to explain particularly why, because I'm basing my assertion that that's not true not only on just what we've heard from sort of the other side. So people like the governor and the mayor have said, no, that's not true. There's no such thing as what they are calling a non-detainable offense. So you have class of offenses where people, the idea is that you have certain offenses, certain allegations of crime where people can be detained, like we can keep them in jail for those reasons that I said. And then you have allegedly this other category of crimes where people are non-detainable. You cannot, under any circumstances, keep them in jail. So not only do we have the people who actually wrote the law and have to implement the law saying that that's not true, I've read the law, and I will tell you where you can read the law, and you can see for yourself that if you just read the law with a little bit of understanding, you will see that's not true. And that's because under the law, there is no such thing as any offense where under no circumstances can you lock them up. So some people would have you believe that anytime anyone is charged with second degree murder, no matter who they are or what we know about their background, they still can't be locked up. That's not true. What has changed is that it's not automatic that you're arrested on second degree murder, you're going to get locked up or post some sort of high bail. That's not automatic. Now, for those certain offenses, and there are a few, the state has to prove certain things. And again, what does the state have to prove now? They have to prove that, well, this person is a flight risk. I gave an outrageous example about friends in another country, but maybe you're also an immigrant and you have ties to another country, or maybe you've done this before in your past where you had a court date and you didn't show up and the police had to go looking for you and bring you back to court. So maybe you have a history of what we call flight. Not showing up to court would be called flight. The state simply has to prove those things. If the state can come in and say this person is a flight risk for some reason, well, then guess what? That person can be locked up under the Safety Act, and they will be. The other thing is, let's say, again, a person charged with second degree murder. Let's say it's some long-standing dispute between people who've had clashes with each other before. These are all just hypothetical situations that I'm making up. You can imagine any number of scenarios, or a domestic situation where the two partners live together, or a familial situation where they're going to have a lot of interaction. And the state can come in and say, well, if we let this person out, they're at risk to do it again. Either because of their circumstances or something about their character or background. This person may try it again, try to finish the job, so to speak. If the state can prove that, then guess what? No matter what the crime is, domestic battery, aggravated battery, second-degree murder. If the state can prove those things, then that person will be locked up. It's only when the state can't prove those things or chooses not to even try to prove those things, where for those certain listed offenses that they just won't automatically get locked up because the state hasn't proven, again, that there's a reason to lock them up.
Wow. I'm not gonna lie, it still feels hard to digest this information. Because it's almost like, and I understand proving that this person is a risk to flee and things like that, but it almost seems as if there still would be opportunity for some of these more serious offenses for people to possibly be out. And so when you say it's up to the state, does that mean the presiding attorney or the prosecutor and all of the that court piece, or is it up to the judge?
No, whenever the state carries the burden of proof, and that burden of proof is clear and convincing evidence. And I will admit, clear and convincing evidence is a relatively high standard of proof. It's more than preponderance of the evidence. It's more than probable cause. It's short of beyond a reasonable doubt. So they don't have to prove these things beyond a reasonable doubt, but they do have to call what's in the legal community called clear and convincing evidence, which is about a medium difficult, I'll say, burden to try to prove. You have to come in with some evidence. You have to come in with some facts. And yes, this will create opportunities where fewer people probably are being held in jail. But remember, first and foremost, remember they're innocent. You could have caught them red-handed doing the crime. They are innocent. Number two, the whole point was to make sure that they come to trial. And there's no reason to believe that they will not. The whole point was to keep them from hurting someone else. And there's no reason to believe that they will. So if there's no reason to believe that they will hurt anyone else, and no reason to believe that they won't come back to trial, and they're innocent, what justification do we have to lock them up?
I understand that. I do still think that's a very difficult pill to swallow, especially with the crime rates just skyrocketing now. And I think that's part of the reason why people have so much concern about the act itself, is just because not only is it happening at a time where crime is skyrocketing, you also have worse police sentiments probably in the history of policing at the moment, and so, that I would assume that this act also makes the police think like, oh man, what am I actually supposed to do? How am I supposed to do my job? You know what I mean? And so I just think it's such a confluence of things at the moment that, man, it really makes it difficult for people to feel good about the act. At the present time, I hear its purpose, though. I thought, especially as it relates to no cash bail, because I recognize that there are a ton of Black and brown people who can't afford, like you say, almost $500, that have been incarcerated for that very small amount of money for a long time. And so it made it much easier for those individuals. But again, when you tacked on some of these other offenses, especially in a time now, it's just like, oh man, what we getting ourselves into. So I get that. I do get it. Is there anything else that you would like to add in the regard of this second part here, which is, like I say, the concern of most people about the serious offenses, or even are there, or can I just go ahead and move to the next question?
Well, let me briefly address this nomenclature of serious offenses.
Okay.
That is a personal value judgment, which of course you are personally entitled to make. But to anyone who is the victim of a crime, that victimization is serious to them.
Yeah, for sure. For sure. For sure.
No matter how quote unquote serious the majority of people would consider it to be,
Mm-hmm.
it's serious to the victim.
Yeah.
It could
Yeah.
be it could be loitering on my land to hitting the back of my car or breaking out my window, or breaking my fence post, something simple, some little damage to property, or some little trespassing, or even a theft of a minor item. To me, that's going to be serious.
Mm-hmm.
So what we have to, so you can't necessarily personalize it in that way, but what we have done as a society is categorize offenses broadly, and that categorization is supposed to reflect our sort of collective view
Mm-hmm.
of what is a serious offense.
Mm-hmm.
And there are what Illinois has deemed to be called forcible felonies.
Mm-hmm.
And if you are charged with a forcible felony, and what that generally means is, well, first of all, there is a list of forcible felonies, but it goes beyond the list. But generally, what we're talking about, something where if you're convicted, again, after a trial, which hasn't happened yet, but if you're convicted, then you have to go to prison. You can't get, for example, probation, a non-probationable offense. So if you think about these non-probationable offenses, where if you get convicted, you must go to jail, probation is not an option, then you can be kept in jail for forcible felonies. And if you want to look at a line, and that's really what you're talking about. You're talking about line drawing between what's a serious crime and what's not a serious crime.
Mm-hmm.
If you want to look at where that line is, individually, you will draw it in different places, and that's perfectly okay. Collectively, as a society, we have drawn it at this line.
Yeah,
And the
understood.
law does protect that line where we as a collective society has decided to draw it.
Okay.
That's number one.
Uh-huh.
Number two, speaking of value judgments, again, this is individual, but people have to decide for themselves, what do they value more? Do they value more a society where a police officer can say, I think you committed a crime, so I'm going to lock you up for years before anybody proves it?
Mm-hmm.
Or do we value society where people can be arrested if we think they may have committed a crime, which is all that's required of police? Probable cause to arrest means I have a good reason to think you may have committed a crime. That's a very loose layman's translation, but generically speaking. So, do we value a society where a person can be locked up in jail, away from their family, lose their job for years on that, based on I have some evidence that makes me think you committed a crime? Or would we rather let that person, if that person is going to not hurt anybody, is going to come to court, do we value more not locking that person up, letting them continue to work, not lose their job automatically, stay with their family, raise their kids? That's something that you have to decide for yourself.
Mm. A great way of putting that. So I do have a guest that wanted to jump in and ask some questions. So if it's okay with you, I'm going to go ahead and bring them in.
Yeah, I'd be happy to try to answer to the best of my ability.
All right. Mr.
Hi.
Knight.
Yep. Hi, my name is Terrence Knight, and I just wanted to ask a few questions, maybe a two-parter. Um, and you all did a good job at answering the previous question, which is pretty much addressing the rumors. So I will pivot to say, what are the contingency plans if the if the act starts to backfire, and is the state uh, you know are they readily ready to take accountability if it does backfire?
Well, you're really asking um, both a political question and it's a somewhat loaded question because there's respectfully, sir. I do respect your question, but it's a somewhat loaded question because there's really no way to answer it because you say if the law backfires. First of all, I don't know what that means. Um, and maybe you can illuminate that a little bit. What when you say it might backfire, what are you particularly thinking yourself might happen?
Let's say that because of the cashless bill, there were more offenses being done upon when a person committed a crime or alleged to be committed a crime and they went back out into society, or they have the luxury of freedom after they committed, say, a crime or whatever, and they commit another crime or a rash of crimes or even more dangerous crime. Like if the statistics shows that that is happening, which to the minds of a lot of people, um, it seemed like it's not working or it's backfiring. As like I think there were a few states that actually reversed it and uh, um, had the bail system back again. If that
Well, a
makes
couple things. Number one, that then becomes a political question. This was passed by your state legislators who represent you, and if you and collectively we as a society are dissatisfied with the operation of this bill, then it's incumbent upon our elected representatives to change it. However, to your concern, um, I would say two things. Number one, we have at least some idea of what is the impact of pretrial release on what's called recidivism. And when you are charged or convicted of one crime and then subsequently commit another crime, that's called recidivism. So we do have some information on the impact of pretrial release on recidivism. And you hear a lot about people alleged on electronic monitoring, for example, currently going out and committing more crimes. And certainly that does happen. However, I think if you look at the facts, you will see that statistics show that there is no greater rate of recidivism among people who are on pretrial release. The statistics simply don't bear that narrative out. And in fact, electronic monitoring has resulted in a greater percentage of people actually coming back to court. I think if you look at the actual facts, you'll find that the statistics show that there's actually has not been any increase in recidivism as a result of any increased use of things like electronic monitoring. That's number one. Number two, again, now those reports I've actually seen. As far as other states that have had modifications to their cash bail system, and again, I think Illinois is the first state to completely abolish. But as to those other states that have had bail reform measures, again, what I've seen reported in the media is that again, the statistics do not bear out that those reforms had a subsequent impact on rates of recidivism. I haven't seen the actual studies myself, but I've seen a very strong counter narrative being reported where we have a number of victim advocacy groups saying that it's simply not true. Bail reform does not increase rates of recidivism. But I encourage you, again, I can't speak to that directly. I'm now just talking about what I've read in the media. But I encourage you to actually look for the actual statistical reports on both of those issues. And I just personally believe, this is just my personal belief, that it just won't happen. Because again, if you're talking about the people who actually do pose a danger to society, it doesn't necessarily, it's not always just limited to danger to a person. Like they don't have to threaten to go out and kill their domestic partner if the state can prove that they're a danger to a community. So if you're talking about people who are actually at risk of doing that, then the state can prove that, again, they need to be locked up to prevent that, and they will be. They still can be. It's just not, the change is we're just not going to assume to do it and make them pay to get out. We're going to ask for some evidence that we need to do this, that we need to deprive them of their right to liberty for a good reason.
Yeah. Great response to a great question. You got another question tonight?
I know that was pretty much it. Everything was, my concerns have been, addressed. So that's pretty much it.
All right, bet. I am going to put you in the back room unless you just want to stay right here. We're going to move forward with the other questions we had.
Yeah, I'll go in the back room. Yeah.
All right.
Thank you for your question, sir. Thank you.
You're welcome.
Thank you for paying attention to these issues as well.
All right. So I know, again, I feel like that was a very good way to put a bow on the serious offenses question. So if there was any other thing you'd like to add, I think we could go ahead and do so. Otherwise, I'd like to go ahead and just move with another question that we had.
Certainly. Let's please. There's one thing I want to address with regard to the bail. There's been talk about the time in which sort of these decisions have to be made, whether the person will get locked up versus not locked up. It is true that you have to have what is called your first appearance within 48 hours. So let's say you get arrested for a crime just by a police officer on the street. Now you haven't been to court, you haven't been to a judge. They have to take you to court and have you appear before a judge currently within 48 hours. And there's an Illinois Supreme Court case that decided that time period. And that's so that a court, an independent judicial review, can determine if the police really did have probable cause that I talked about earlier to arrest you. Now, under the Safety Act, before I go to that, and again, the state can file a petition to keep you locked up. But again, now, rather than it being automatic that we just assume that the person is going to get locked up before trial, now the state has to file a petition and say, no, we do need to lock this person up. Yeah, for those forcible felonies, that process occurs within 48 hours. The hearing. There is another class of offenses where they can get up to 21 days to have a pretrial detention hearing. But again, that's for those offenses where the non-forcible felonies, the probationable offenses, which again, I talked about this value judgment to what's a serious crime versus what's not a serious crime. If we as a society has decided that you can get probation if you're guilty, then is it fair to call that a serious crime? Maybe, again, to you personally, it is. And I agree and respect that. But the question is, does society call it that? So, but I think that's a good place to wrap up. I understand people are afraid and concerned that violent, dangerous criminals are not going to get are going to be free to continue their criminal rampage. Simply not true. All we're asking is that there be some evidence that, for lack of a better word, that's going to happen.
Understood. All right. So we can go ahead and move on to the next question, because I think this is something that people have had concerns about, and that was this piece about people being allowed to trespass on your property. And
Right. So I've heard that too, where people are now saying that there could be a trespasser and the police can basically do nothing except issue them a ticket. And again, that would be a crime where they cannot be detained before their trial. Again, unless they're a serious flight risk, have a serious mental health issue. If the state can prove that, then they can still be locked up. But absent those considerations, trespassing would be a crime where you have to get out before trial. But we have to remember that there's a difference between removing someone from the scene of where they're committing the crime, where they're actually doing the trespassing, and locking them up before trial. Detention before trial can last, as I said, anywhere up to years. So all we're saying is that won't happen anymore. They won't just be locked up for years to await their trial on a simple trespassing. But the police can remove them from that scene, take them to the police station, issue them a ticket, because that's what the law now requires for these offenses. They issue them a ticket, and that's where the 21 days comes in, where they can have their hearing on whether or not they'll be locked up. If they get a ticket, they can get up to 21 days. But the police can take them off your property, take them to the station, give them the ticket, and then let them go from the station, which is exactly the same thing would happen if they posted bail. Let's say they got $1,000 bail. They only needed $100 to bond out. They had $100 in their pocket. They would walk out just as quickly as they did after getting a ticket. Maybe not just as quickly, but almost as quickly as if they just get a ticket and they're released from the police station. So it's not creating any new risk, in my opinion. But they can and will take people off of the property. And I think we still have the infographic up on the scene. Admittedly, the law itself doesn't say that, but that's where interpretation by the court comes in. And there's a commission, or it's not a commission, it's actually a task force of the court that's looking at this law, and that's the way they have interpreted it. And as you can see from the infographic, that comes from the Supreme Court Pretrial Implementation Task Force. So that's going to be very, very persuasive into what this law means. And what they're telling us it means is no, take them if it's a citationable offenses, and you can see that in the flow chart. Can they get a citation? Yes. Take them to the station, issue a citation, and let them go.
Okay, so people cannot just sit in your home unwanted. If you don't want them on your property or in your property, you can call the officers. They'll escort them out, take them to the station where they'll be cited there.
That is correct. Okay. That is what the Supreme Court Implementation Task Force has instructed us is the way this law should be implemented. Okay. Granted, does the law say that explicitly? Does it say word for word to do that process? No. Right. But any law is going to have to be interpreted by a court. And now we're getting some very authoritative opinion that says what you just described is yes, that's exactly what the law says should happen.
Okay. That's good to hear. I think a lot of people will find some comfort in knowing that, because I think the sentiment was that you can have unwanted house guests. The police, you call the police, and yeah, nothing we could do about that, and that be that, So that's good information. And in regards of this particular question, is there anything else that you wanted to add?
No, but that was important because not only were, private residents, as you say, homeowners, if you don't want somebody there, they were concerned. There's also been a lot of concern from like different landlord associations about what they could do about squatters, particularly on vacants, which we know is a big problem. Mm-hmm. So no, all indications are that, yes, you take them off the property, take them to the jail. That's where you issue the ticket, and then you let them go from the jail station. And let me also say, the gentleman before, one of my answers to him was that he's talking about a political question because then you need a legislative solution. As these, sort of small gaps come to light, there will be efforts, and they're already underway to sort of plug those holes and to clean that language up, which is very typical of any legislation that happens.
Yeah. All right. Well, unless there's anything else that wasn't addressed that you would just like to add for comfort's sake, I don't have any other questions. Do you?
Well, first of all,
not any questions, any answers, I should say. I'm sorry.
Just again, everybody's been talking about, we're going to have the purge on January 1st. We're not. On January 1st, most of us are not going to see a thing. Nothing in our everyday lives is going to change. There will not be in my opinion, there will not be a flood of very dangerous criminals back on the street because the state will be able to prove that person is a serious risk of flight, a threat to an individual, or a threat to the community. And they can prove that by clear and convincing evidence. They can still be locked up. We just need some sort of proof.
Yeah. I do want to help with a little bit, I guess, illustrating that point. So again, as you spoke a bit earlier, if an offender in the past, let's just say, this is a hypothetical, let's say they went to court on a traffic ticket and the court had to go find them to bring them to court. And that same individual committed one of these more major offenses that people are worried about, like I think it was second-degree murder, I think you mentioned. Because in the past something had happened like that, would that already mean that person is a potential risk, so that person then would get locked up?
That can be evidence. Yes, absolutely. If they had more or less, if they had done it before, then yes, that the statute actually lists certain factors that you can consider, that the court should consider in determining whether or not a person is a flight risk. And having previously flown, yes, that is definitely something that the statute says should be considered.
Okay.
If I understood the question correctly.
Okay. Yeah. I feel like I feel like I asked it correctly, but now
strictly me trying to make sure I got it, the gist of it.
I got you. And so I guess a little bit of house clean. I just wanted to make sure that I brought back up the ICJIA.illinois.gov, where people can actually read more about the act. And again, if you're not following along with this right here, then read for yourself, please.
And speaking of reading for yourself, now I'm going to admit that I'm going to give you something else if you wouldn't mind putting it up.
Sure.
And I'm going to admit that for all my non-lawyer friends, it's not easy to read. But if you actually want to read this law, I'm going to give you what to type into your search engine. It could be Google, DuckDuckGo, whatever you use to search. All you really have to do is type in what we're about to put on the screen, and the law will come up. You can read the actual law for yourself. And this is what you need to type in. You need to type in 725 ILCS 5/110-6.1. Point one, yes.
Okay.
If you just put that in any search box, you may want, I don't know if you necessarily need spaces, but there should be a space after the first five, the S, and the S. That's it. So just separate out the ILCS if you can. And I'll just tell everybody, ILCS is an abbreviation for Illinois Compiled Statutes. So this is the actual bail reform statute. It's not the whole Safety Act, because remember, the Safety Act does a lot. But this is the actual just bail reform. You don't need the act, but if you just type in starting with the 7, that's the actual statute number. And if you just, I'll just say Google it. If you just Google that, the law will come up. You can, if it would be difficult, I'll admit, but you can see it for yourself, and you can work through it. But it's not easy for non-lawyers. It wasn't easy for a lawyer, but again, you can read it for yourself and look at many sources of information. We have some people who are running for office. Let's just be frank, saying things about the current administration and all the bad things they've been doing. But take multiple pieces of information from different sources and put it all together and see what sounds right to you.
And read it for yourself, if nothing else.
That's the best.
So before we head out, I want to make sure that I do one more thing, which is to put our handy dandy disclaimer up and make sure that everybody understands that this is just an education. This information is not to be used in the court of law or anything like that. This is not counsel. This is just education and information so that we all understand what's going on with the Safety Act.
And we will be back as needed, because we want you. I know I do, and I know Deondre does. We want you to have the information. So as we need to be, I know I'll be back, and I'm sure Deondre will too. I'm sure he'll have me back. I hope he'll have me back.
Yes, sir. I'm like I said, I'm gonna chop this up. I think this was great. This does get at the heart of some of the questions that the people have been asking me, that I've been seeing online. So hopefully the people gravitate toward it and they're able to get the information that they're looking for. And then they have questions so that we can come back and do it once again. And if we just have to come back and do it once again, I'm open to it. And I thank you for being open to it as well. And thank you for your time today.
Yes, sir. Glad to do it always. Thank you.
Yes, sir. All right. Mr. Williams, you have a good day. And thank you once again.
Thank you, everyone.
All right.